Hey everybody, Sean Bukowski here. Hope you're all having a great week. Here in Austin, we're getting ready for the beginning of South by. It's always an exciting time of year. I know some people don't love it, but I love it. I think it's fun. It's exciting. It brings energy to the city, and there's a lot of cool stuff going on. So get out there and take advantage of it if you can. This week, I want to talk a little bit about one of the sort of streamlined processes that makes it good to be, sort of developer, landlord, whatever, a real estate owner here in Texas, and that's our relatively streamlined eviction process for in residential real estate. I know that some people might think it's not that streamlined, and certainly in cities like Austin, where they have added things that go beyond what the state requires, it can be a little harrowing sometimes. But I promise you, as someone who has some property in Michigan, it's much easier and cleaner property than it is up there and in many other states. So we want to talk a little bit about how that process works. You may know this already, but the first thing you have to do, again, I'm not going to talk about the stuff you have to do in Austin now. You can read the previous blogs about how they've changed the rules. But the first thing you need to do is file a notice to send a notice to vacate to the tenant. And they have 3 days. You can basically set it any time after 3 days. They have to vacate the apartment to move the apartment or house or whatever. And if they don't, that's when you can file for an eviction with the JP court. At the hearing, it's pretty straightforward. You just have to show the reason for the eviction. You have to show the lease. They have show proof that you sent them a notice to vacate, and then the reason for the eviction, which often is failure to pay. And failure to pay, the easiest way to do that is to show the lease and then have the records of non-payment. So however you keep your records, bring those to the court, to the JP court. Obviously, the tenant has their right to make their argument in court while they shouldn't be evicted. But if if landlord wins, then the court will issue a writ of possession, and that's when you can get the constable or sheriff involved and actually get the possession to the apartment back. Obviously, not obviously, the tenant does have the right to appeal. They can appeal that to county court. And it's really at this stage, if they do appeal, that we highly suggest getting a lawyer involved. This is where us as Bukowski Law Firm will generally become involved, and that's because at the JP court level, really the landlord can, as long as they're versed in what they have to do, can handle that themselves. But once you get to the county court, I should say, it becomes more involved and there's more procedure, and it's just worthwhile to have a lawyer at that stage of the proceedings, and so that's when we would generally get involved. That to appeal, the tenant does have to file a bond. It's usually the amount of a month's rent or the amount due, and they can also, if they can't afford the bond, they can file for a pauper's affidavit, which basically relieves them of that. You can challenge that, but that's a whole other sort of story and issue that goes into it. But at that point, they will appeal, and it basically starts over in county court, and you'll have to go through trial again. But if you win at that stage, then the writ of possession goes through, and you're able to get the unit back. This is, like I said, a much easier, much more streamlined process than in a lot of other states, and it helps Texas landlords keep those rents. I mean, I know they're skyrocketing, but they have skyrocketed in the past, but generally lower than they would have been. Well, if you enjoy that, please subscribe to our blog, to our YouTube channel, and to our podcast. Have a great day.